Yes, Mr. Green.
Thank you very much. I was dealing with the general position, which is that clause 6 is not where one looks for the purpose of understanding the temporal scope of clause 12.2, and I'd made the point that it was no part of Santander's case at trial, that that's where you do look. But can we just now look at clause 6? And it too must obviously be read in the light of clause 1.2, so as one is looking to see whether it otherwise states. Now, although, of course, in clause 6, the words will and will not are on the face of it forward-looking, it begs the question as to the point in time from when they're forward-looking. It doesn't, for example, say they're forward-looking from the effective date, and in this respect one contrasts, for example, clause 9.1. But on the contrary, various provisions in clause 6 refer to the insurance, i.e. as defined, rather than, for example, to new policies. So if, for example, you look at 6.1a, which is the primary obligation on GECB, is to observe the insurer's reasonable instructions and to use its best endeavours to market and sell the insurance. So on any view, the definition of the insurance is both forward-looking and also backward-looking. That definition applies to historic policies. And you see, again, 6.1F.
It's a very odd way of phrasing that kind of a composite obligation, isn't it?
Well, my lord, I've already made the point that what the parties were doing is they weren't changing anything as of the 1st of December 2000. What they were doing is they were recording the practices that they had been operating for many years in relation to what were then becoming historic policies, and they were recording the practice that was going to apply going forward for new policies. So that's why nobody, that's why they used the wording they used. And they no doubt used the wording the insurance rather than new policies deliberately. If, for example, you look at 6.1L right at the end. So GECB will, as soon as reasonably possible, after receiving the insurance instruction to do so, pay sums to insured customers on behalf of the insurers in settlement of claims made under existing on-risk policies and new policies. So where they wanted to draw a distinction between existing on-risk policies, new policies, and the broader insurance, they did so. So when in 6.1 they refer to the insurance, and when in 6.1F they refer to the insurance, and when in 6.1G they refer to the insurance, one has to assume that they did so deliberately, and that that is intended to encompass not only future policies, but also the policies that had already been written. And that fits entirely and consistently with the fact that what the parties were doing was recording the agency relationship and the duties that had applied for decades and were going to continue to apply. Nothing had changed. It was business as usual, as the judge found, and the existing arrangements were the arrangements that had existed for decades and were going to continue to exist going forward. And now so clause.
Can I just ask you a couple of questions arising out of that submission?
Of course.
It's a long time since I drafted particulars of claim, at any rate in anger. I'm just thinking about how you would plead a claim. You say, by an agreement made on the 1st of December 2000, the defendant agreed that it would, without prejudice, blah, blah, act in good faith. And on the 1st of December 1995, in breach of agreement, it did this, that, and the other? It's a very odd claim, isn't it?
You would plead that the parties acknowledged that the provision set out in clause 6.1 applied from the outset of their relationship, their agency relationship.
Right. And when would the limitation period start to run?
Well, the limitation period would start to run 6 years from the date of the breach that was being pleaded.
Even though there was no agreement, no binding agreement in force at the time.
Well, there was no written agreement, but the parties still had, as Mr. Howard accepted this morning, the parties still had contractual arrangements, albeit not written down. There's no logical difficulty with it. Now, we come to clause 7, and does clause 7 otherwise state? And of course, my lord, it has to be read in the context of clause 1.2, notwithstanding clause 3, i.e. notwithstanding that on the face of it, this agreement commences on the effective date. This agreement shall apply to and govern the marketing and sale of insurance under all of the schemes, including the schemes written in 1970.
So,
That's what
the
clause
phrase,
1.
so the phrase during the term of this agreement means going right back to 1970.
Sorry, in which clause?
7.
Oh, now, well, I'm just coming to clause 7.
Oh, sorry, I thought you were talking about this.
No, I was talking about clause 6 and clause 1.2. I was just quoting from clause 1.2. Now, clause 7, does it otherwise state? Now, on the one hand, you do have a reference to the insurance. So you see references to the insurance of 7.1a and 7.1b. But I do accept that what you then have on the other hand is you have the words during the term of this agreement. And those words are obviously more difficult to see as clause 7 being truly retrospective in the way that the Santander contends. But as Santander argued at trial, and we say rightly so, these clause 7 obligations apply throughout the duration of the agency relationship. That was their position at trial. These did apply from the start. So when they were saying there was non-compliance with the opening words of clause 12.2, their position was not, let's look to the common law duties, which applied at the time, which they could have done and logically is perfectly justifiable. But they said, actually, when all of these policies were marketed and sold, the relevant obligations were those in clause 5.1 and clause 7. That's what they relied on. Now, and what that reflects is the fact that the parties were writing down on the 1st of December 2000 what they considered their existing practices and expectations to be. So until my learned friend raised the point today, which doesn't appear in his skeleton, until he raised it today in the context of the opening words of 12.2, sorry, it's that which he doesn't deal with in his skeleton, those opening words. Until he raised the point today, Santander proceeded on the assumption that the clause 7 obligations apply throughout their relationship. And that reflects what the parties understood the position to be. And I mean, just looking at the opening words of clause 12.2, now the words duties under this agreement obviously bear the same meaning as in the concluding words. So it's duties governed by this agreement or the duties to which it applies. Now, here it is necessary for GECB to prove a breach. And so GECB does have to identify the specific duties breached. And in that sense, the application of these words is different to the 7 last words, because you'll recall that my Lord Justice Lewison asked my learned friend, did the judge make a finding about the duties that set the scope of the indemnity? And my learned friend very fairly said that it doesn't depend on showing a breach of duties by GECB. This is dealing with the last 7 words. He said it doesn't depend on showing a breach of duty. The relevant duty is the duty of selling. Well, that's absolutely right. It was the duty of selling. And the only question is whether or not those final words include the duty of selling prospectively or also the duty of selling in relation to historic policies. But the first words, you do actually have to establish a breach. And so in that sense, the application of the first part of 12.2 is different from the application of the final words, which don't require a breach. What duties do you look in relation to the first words, the first part of 12.2? One looks to the duties to which Santander looked at trial, namely clause 5.1 and 7, which applied throughout the duration of the relationship, so both before and after the 1st of December 2000. But alternatively, Santander would also be able to invoke the common law duties owed by a principal to an agent. But it wouldn't need to do so, given the application of clauses 5.1 and 7, and it didn't do so at trial, but it would also have been able to invoke the common law duties, which in some ways wouldn't be terribly different to the contractual duties. So there is no difficulty and there is no mismatch between the opening words of 7.1 and the concluding words of 12.1. And so just coming to the concluding words, what do they mean? What duties are being referred to? As I said at the outset, the words duties under the agreement, duties under this agreement, is just a reference to the duties which are governed by the agreement, or the duties to which the agreement applies, which is using the wording of clause 1.2. And it's clause 1.2 that sets out the agreed scope of the parties' respective duties. And it makes clear that the agency agreement applies to and governs the parties' rights and obligations, so their duties, in respect of the activities identified in the first and second limbs. So, per the first limb, the agency agreement applies to and governs the parties' duties in respect of the marketing and selling of the policies covered by the first limb, which are both historic and future policies. And so the indemnity bites if there is a liability incurred by Fickle and Fackle by reason of any act or omission by GECB while marketing and selling the insurance as defined. And that is the finding, if we can just go to the judgment, that is the finding that the judge makes in paragraph 278.
Yes.
And she concludes the restriction thus relates to the scope of the agency rather than being temporal. So the concluding words connects the liability under 12.2 to GECB's activities as governed by this agency agreement. And if AXA needs to identify the content of specific duties, which I say we don't, they are either the duties memorialised in clause 6, or clause 5.1 and 6, or the common law duty of care, which was owed by GECB when marketing and selling on behalf of Fickle and Fackle. And you see in clause 12.2, there is a reference to including negligence. And what this shows is that clause 12.2 expressly captures acts or omissions beyond breaches of specific contractual duties. So whatever duties were owed at the time of the marketing and selling, whether under the contract or at common law. And the same would apply to the opening words. And it's worth making this point. One obviously has to address what was the connective purpose of these words. Was it a real and helpful one? The answer is yes, because this was a decades-old relationship involving, over time, a dizzying array of different corporate entities. And there might therefore have been other types of policy, non-PPI or personal accident, which had from time to time been sold by GECB or its predecessors on behalf of Fickle and Fackle. And these concluding words made clear that if so, those activities were not within the scope of the indemnity. It related to the activities covered by clause 1.2. And equally, if Fickle and Fackle and GECB, after the effective date of the agency agreement, had agreed that GECB could sell insurance products under a distinct arrangement and they were different from the insurance as defined, so outside the schemes in the addenda, these words make clear that that wouldn't apply to that arrangement. So they serve that connective purpose. They do not serve a temporal purpose. Now, can I just deal briefly with clause 17, the whole agreement clause? This too must be construed in the light of clause 1.2. One doesn't use clause 17 to rewrite and cut down the scope of 1.2. And the proper construction of clause 17 is that from the effective date, the written agency agreement is the sole document to which one looks when considering the rights and obligations of the parties in respect of the marketing and sale of insurance as defined. And of course, it is common ground that earlier draft agreements had been produced from 1996 and possibly slightly earlier. And clause 17 was simply making clear that this agency agreement was now the sole document governing the parties' relationship. And unlike clause 1.2, it doesn't set out the scope of the parties' rights and obligations in respect of both new policies and historic policies. It doesn't mention historic policies. It certainly doesn't seek to exclude them. And on the contrary, it uses the definition of insurance, which covers both new policies and historic policies. And what clause 17 is doing is something different from 1.2. It's doing what the judge rightly found in paragraph 277 of her judgment, which is that it merely confirms that the agency agreement regime applies from the effective date. And the words from and including the effective date qualify the words the entire and only agreement between the parties, and not the words the marketing and sale of insurance. So that's clause 17. Can I finally deal briefly with the asymmetry point? Now, AXA's construction arguments focus heavily on textual analysis of the provisions in the agency agreement. So this is not a case where AXA is inviting the court to allow commercial common sense to override the textual analysis. Our position is simply that the asymmetry argument provides confirmation that the textual analysis is correct. Now, the asymmetry point is simply this. It's that in circumstances where the parties decided that no line in the sand was being drawn in respect of historic policies, which were for all other purposes brought within the scope of the contractual regime, there is no obvious commercial reason as to why the parties would treat them differently when it came to the indemnity. And on the contrary, where the parties were expressly recording in writing a decades-long agency relationship, and they were bringing within that agreement all historic and future policies, including the ongoing financial benefits of those millions of historic policies, the overwhelming likelihood, absent clear wording to the contrary, is that all policies were included for all purposes. And that's a particularly compelling point in circumstances where the indemnity covered the mis-selling of policies which were designed by GECB, were priced by GECB, and where GECB had at all times total control of all aspects of the marketing and sale of those policies, and indeed received 95% of the monies that their sales generated. And what then was the commercial logic for the indemnity to cover future policies but not historic ones? And why, importantly, exclude such policies from the indemnity when historically GECB had paid out when a customer had a mis-selling complaint? I took the court to that paragraph. So yes, of course the contractual indemnity was new, but it reflected the existing practice of the parties. And the judge rightly found in paragraph 279 that the commercial asymmetry argument was a compelling one because it marries risk and reward, whereas Santander's construction doesn't. Yeah. And it is no answer for Santander to say, as they do in paragraph 63 of their skeleton, that the parties agreed to exclude historic policies from the indemnity because they were part of the same corporate group. That there is no evidence, even if it were admissible, that such thinking existed at the time. And furthermore, the parties had not consistently been under common ownership throughout the agency relationship, and there's no basis to find that the parties drafted the agency agreement on the assumption that common ownership would continue indefinitely. So we do say that the asymmetry point, as with the textual analysis, points in the same direction, which is that historic policies are indeed covered by the indemnity. I'm told I'm allowed to sit down.
Mr. Howard, do you wish to reply?
Lord, I'll be brief. As you know, there are two issues. The first is, does the agreement provide for any retrospectivity? And secondly, in any event is clause 12.2 retrospectives. Can I take 12.2 first? Of course, AXA's argument on retrospectivity of 12.2 is dependent on their argument on 1.2. As has been pointed out, 1.2 says, unless otherwise stated. Now, Mr. Green was asked by the court, where are provisions which fall within otherwise stated? He said, aha, it's clause 9, which is dealing with profit share and has a reference, that's on page 8, to after the effective date. Now, in fact, clause 9 is not part of the unless otherwise stated because it's dealing with administration, which isn't actually, it's common ground that administration is prospective and not historical. But in any event, it's quite irrelevant. The question is, what about 12.1 and 12.2? Now, Mr. Green appears to say that whenever he's confronted with a difficulty in relation to clauses, well, you've got to read them as subordinate to 1.2, and they've got to be read to fit in with 1.2. But with respect, that makes no sense at all. 1.2 is subject to what the other clauses state. So you have to decide what they state. Now, an assertion was made, and that's what it was, that clause 12 is a boilerplate clause, which has just been taken from some other, well, I suppose from, I don't know where he says it's come from, but it's boilerplate. Now, the first thing is that's assertion. It's not a finding of the judge. It's Mr. Green's assertion. Secondly, it, even as an assertion, it goes nowhere. On AXA's case, everything else in the agency agreement was reflecting, for instance, the standards of performance, what had gone before. There was one thing that was fundamentally new, and that was the indemnity provision. So clause 12, whether the parties have borrowed or taken from somewhere else, is a clause that you would expect that the parties have actually paid attention to, because it's actually introducing something on any event new. Now, Mr. Green said that Santander is saying something different about the first part of the clause to what we said below. Now, the first answer to that is untrue, wrong and untrue, and I'm surprised it's said because Mr. Green himself took you to the closing submissions, which themselves make the point that clause 7 does not apply to a period prior to the agreement, and therefore there was a mismatch. It's actually at paragraph 115 of the trial closing, which he referred you to. The latter part of the closing, which is then treating clause 7 as if it did have relevant provisions, was just dealing with the case that was being made against us. So the case against us was that all these provisions apply, and so Santander was responding to that and saying, well, on that basis, you haven't complied with clause 7 at any stage. But our case has always been, and it's also in our argument, written argument here as well as the oral argument, that clause 7 is incapable of applying other than during the term of the agreement, because that's what it says. Now, that then takes you to the points I made about clause 12 and the symmetry between the opening part of clause 12 and the second part. Now, as I heard my learned friend, he essentially doesn't have any response to that. If clause 7, which is what defines the insurer's agreement, only operates during the term of the agreement and during runoff, then that turns his argument just doesn't make sense. And I think he accepts he has to somehow mould that language, and in our submission you can't do that. Now, the other point that, as I understand it, Mr. Green accepted in answer to a question from Lord Justice Lewison, when he was dealing with this being a boilerplate clause, he accepts that the ordinary language here is only apt to work prospectively. So that's what the words mean. And that's the difficulty. The parties have chosen that, and you can't then say, well, I don't like that, let's apply something else. Now, he then said, well, if you agree with what Santander say, his words were that emasculates 1.2. Now, of course, it doesn't. That's all based firstly on the premise that 1.2 is retrospective. But in any event, on their case, it doesn't emasculate 1.2. It simply provides that this indemnity only applies in certain circumstances. Everything else in the agreement on Mr. Green's case applies. It's just clause 12 doesn't. So it doesn't create any problem. A submission was then made that the duties being referred to in 12.2 in the last clause while performing their duties under this agreement is not a reference to clause 6 of the agreement. I'm afraid I don't understand that submission. It plainly is a reference to clauses 5, 6, 8, and 9, which contain the duties under the agreement which are imposed on GECB. And you have to remember, acts or omissions are in this are referring to two things: sales or administration. The indemnity also applies to liability that the insurers incur by reason of some administrative act that is undertaken. And when you realise, therefore, you can, for acts or omissions, one is just looking at sales or administration, that emphasises or makes clear that while performing their duties under the agreement, plainly has both a temporal aspect, because you can only refer to somebody saying while performing their duties under the agreement if you are referring to the period after the agreement came into being. So that's what I wanted to say about clause 12. As to the position on clause 1.2, the first thing I'd just like to point out, my learned friend's submissions are confused when he deals with administration. Administration is only on any view covered by this agreement in relation to administration that takes place after the 1st of December, on or after the 1st of December. And indeed, if one reads my learned friend's skeleton for the Court of Appeal, that appears to be common ground. So that provides support that marketing and sales are also intended to be prospective. Now, the second point he made I think in his introductory submissions was that the agreement was intended to be the formulation of all that had gone before. But we know that's wrong because although they had argued below that there was an indemnity at all stages, the learned judge rejected that. And so the agreement was introducing an indemnity. You have my submission on clauses 5 and 6 and 7 as to how they can only relate to the position post the 1st of December. My learned friend constantly in his submissions, as in writing, seeks to say that there's the fact that the parties in 1.2 use the expression insurance under the schemes rather than new policies is indicative that they intended it to be retrospective. And what he didn't address, and I suspect he didn't address it because he hasn't an answer, is that there is a difference between defining the scope of the authority, and that's what 1.2 does, namely defines the scope of the authority by reference to the schemes, insurance under the schemes, and policies, whether existing policies or new policies, which are the product of the exercise of authority. And it was revealing that Mr. Green had nothing to say about that. Then clause 17, I don't think I need to say anything further. We say the language is clear that from effective date means that it only covers marketing and sale from that date. The final point, asymmetry. Mr. Green seems to want to have it both ways. He says, well, we now only rely on it as confirmation. The judge, as you've seen, actually used it much more, and she was wrong. The parties agree it's all about the words, but insofar as one is interested in the asymmetry, it's just a false point. It was for the parties to choose how to allocate their risks and rewards. The parties for 25 years have chosen to have the position simply governed by the common law obligations. From the 1st of December, they introduced an indemnity. There's nothing surprising either way, other than it's surprising if you actually backdate something to cover a previous quarter of a century. That is a pretty unusual thing to do. So that's what I wanted to say in reply.
Thank you very much.
Yeah.
Very, very quickly. It's a small point, and you may well say that it doesn't take your argument any further. You rather dismiss the boilerplate accusation in relation to the indemnity provision, and so it's purely an assertion on the part of Mr. Green. It's not quite fair, is it? Because the judge looks at the expert evidence and looks at the provisions in the contracts which were appended to the expert evidence, and says that there was something material identical in all of those, and then contrasts it with bespoke.
Yeah,
You want to
well,
nuance
what I meant was it depends what you mean by bespoke. You know, there are lots of cases where, you know, for instance, with standard insurance provisions or charter party provisions, where parties have incorporated something, and you can say, well, nobody's really thought about that. Here, the parties may have taken this off the shelf, but it's something that they've specifically, we would suggest. There's no reason to think they haven't specifically considered this, because this is the new provision that's coming in. So that's what I mean. If by bespoke, and that's what Mr. Green was trying to get at, he was trying to say, oh, well, nobody thought about this, it just sort of been added in. What we say is there's absolutely no basis to adopt that approach. So it's actually just an irrelevance, exactly whether they've taken it, whether they drafted it themselves or used it from another agreement. I hope that answers your point.
Right.
Why was it after 25 years that this agreement was entered into on the 1st of December 2000?
I mean, I think the evidence, shows the parties. I'm not sure I can give you a sort of clear reason.
But it happens to be the date when the 2000 Act came into force.
I don't think it was because of that, if that's what you're saying. Was this not least insofar as you're looking? Do you mean FSMA? Yeah. You've got to remember at that stage, and the judge says nobody was really anticipating the mis-selling merry-go-round, if I can call it that.
Well, I think that also the judge says that this has been under negotiation for donkey's years.
Exactly.
It's
You
been
know,
drafted fairly soon
Yes.
before, in 1906.
yeah, I think it's a coincidence that FSMA, it's not, they're not executing this thinking, oh, we've got FSMA coming in, and not least if you've been
On either side
no,
seems to.
and if you think about it, if you've been
wanted to clear it out of the way in case it might.
it's
Have some
no,
implications.
and if one thinks about it, my lord, let's assume on the 30th of November, people are sitting down and saying, there's 600 million coming in on PPI missed sales. There'd obviously be a very serious negotiation about it, and nobody's suggesting anything like that happened. And the reason for that is, although I think the judge says that sometime just before 2000 there'd been, I think, some expression about selling of PPI, no one at the time, and for some considerable years, really saw the tsunami. Because you remember, people carry on selling PPI well into the noughties.
Sorry, I asked. It's reassuring to have the answer.
Yeah,
Thank you.
I'm grateful.
Right, thank you very much. Good. We didn't need a day and a half for that appeal. Now, let's we get on to the cross appeal.
I think that's one thing we can all agree on.
Mr. Campbell is going to be dealing with the cross appeal.
Right. Yes, Mr. Campbell.
Good afternoon. As the court knows, AXA's cross appeal relates to its contribution claim against GECB in respect of only two heads of loss suffered by Fickle Fackle. Firstly, redress payments made to customers under the FSMA DISP regime, and secondly, a sum paid to the official receiver under what we've called the official receiver settlement by way of bulk settlement in relation to putative complaints on behalf of a large number of bankrupt estates where the bankrupts had bought PPI policies. Our first two grounds concern Fickle-Fackle's liability, the question of whether Fickle-Fackle were liable for the purposes of the Contribution Act 1978 for redress payments and whether also the official receiver settlement can be said to attract the special deeming provision of section 1(4) of the Contribution Act regarding bona fide settlements.
And by liable, you mean, could a judgment in a court of law have been given against Fickle?
Yes, exactly right. And then the third and fourth grounds concern the other side of the coin, which is whether GECB was liable to customers for the same damage compensated for by those sums. Ground 3, we say GECB was liable to customers in common law negligence pursuant to a duty of care. And ground 4, alternatively, we say GECB is liable under the unfair relationships regime of sections 140A and 140B of the Consumer Credit Act. And you will know from your reading that the cross appeal is limited to questions of legal principle under each of those heads. To the extent that you are with me and subject to your view on disposal of the appeal, we will be seeking remittal to the commercial court to apply this court's findings on legal principle to the sample of complaint files that is before the commercial court and has already been subject to some findings by the learned judge.
So, to what extent are you asking us to rule on purely hypothetical facts?
I think I'm not even asking you to rule necessarily on hypothetical facts so much as on points of principle as to whether a type of liability, for example, for the first ground satisfies the requirements of the Contribution Act. So,
well, I'm thinking, for example, of the judge's, I'm not quite sure whether to call it a finding, an observation,
yes,
that as far as she could see, the insurers complied with the provisions of DISP,
yes,
both in considering claims and in complying, if there were any, with awards of the Ombudsman. And I mean, I don't know, can't see from the judgment whether there were any such awards. So just to take that latter one,
yes.
are you saying that for the purpose of your cross appeal, we must assume, firstly, that there are Ombudsman awards, secondly, that insurers failed to comply with Ombudsman's awards, therefore breaching DISP, with the consequence that a disgruntled claimant could have brought an action against insurers? Because that all seems, at the moment, to me, to be entirely hypothetical.
The answer, my lord, is as to Ombudsman awards, there were no final money awards. In other words, the very final process of the Ombudsman process was not reached.
Right.
There were what are called provisional determinations.
Yes.
And I'll show you in a moment, if I may, the provisions of DISP that deal with that. But those were made. There's no dispute that there were that most of the redress claimed in this case was paid. Either most of it was determinations made not by the Ombudsman, but instead by Fickle-Fackle themselves, or on behalf of Fickle-Fackle by their appointed complaints handlers. Some were then referred to the Ombudsman, and those were subject to provisional determinations which were satisfied. As to the question of whether they were satisfied, the evidence said, I don't think there's any dispute, that there was compliance with the provisional determinations.
So we are being asked to assume a counterfactual in which there was no compliance, or late compliance, are we?
Yeah, well, you're being asked to consider, in a nutshell, whether, having determined that redress is payable under DISP themselves, or whether having been told by the Ombudsman provisionally that they should pay, that constituted a liability to pay. And in very simple terms, my submission will be that when there was such a determination or such by either Fickle Fackle or by the Ombudsman, there was a legal liability in the sense that if it was not paid, the redress could be sued for under section 138D of FISMA. And that is the question of principle is that a sufficient liability? So, but your lordship brings me on then to ground one. And if I may, ground one in my submission turns on three propositions, which I'd like to tell you what they are, and then briefly, or hopefully briefly, take you to the regulatory provisions and the statutory provisions to make them good. The first proposition is this: when Fickle Fackle paid that redress to consumers under the DISP regime, they were thereby providing compensation to those consumers for the damage suffered by those consumers as a result of having been missold PPI. And I don't understand that to be in dispute, but it's an important building block of the argument, and so I'll show you the provisions. The second proposition, as I've just said, if Fickle Fackle had failed to pay that redress, each consumer could have sued for payment of that compensation in the civil courts by way of a private law claim under section 138D of FISMA. And again, I don't believe that's in dispute, but I'll try and show you briefly the provisions. And then the third point is the real battleground, which requires a close scrutiny of the Contribution Act, which is that enough to establish a liability for the purposes of that Act? And we say yes. If one pays an amount of money to the victim of damage under legal compulsion, and in circumstances where if it's not paid, that person has a private law claim for that sum of damage, then you are, for the purpose of the Act, liable. And you can claim contribution against another person, in this case we say GECB, who's also liable. So in terms of the first process, what was the DISP redress process doing and compensating for? Could we look please at the judgment, paragraph 75, which is the core bundle, tab 9, page 119. And I understand the court has done its reading, and so when I become too pedestrian, please do speed me up.
Yeah.
The judge here summarises in paragraph 75 the regulatory redress system since the 1st of December 2001. And she refers there to the DISP section of the FCA handbook. Pausing there, the FCA handbook is delegated legislation made by the FCA under rulemaking powers contained in FISMA. She refers then in the second half of 75A to Appendix 3 of DISP, which sets out the detailed regime specifically for PPI complaints. Letter B, the customer can make a regulatory complaint directly against a regulated financial services company. The company may choose to offer redress in response and must decide whether or not to do so by applying the appropriate procedures. Letter C, if the complaint is rejected or the customer disputes the offer, it can refer the complaint to the Financial Ombudsman Service. And D, if the FOS has jurisdiction, it will assess it in accordance with broad principles of fairness, etc. And I draw your attention particularly to the last two sentences of letter D. Redress is calculated by reference to the amount necessary to put complainants in the same financial position as if the PPI had not been sold to them. This is generally taken to be the premium plus interest, and that was indeed the calculation that took place in the cases that we are concerned with. And just for your note, those last two sentences of that paragraph accurately reflect DISP Appendix 3, paragraphs 3.72 and 3.73, which are separately in the authorities bundle, page 67. And so my submission there is that DISP redress paid out to customers was compensation for the damage suffered by customers having bought PPI that they would not have bought in the absence of mis-selling. And that is why the judge was right to find that Fickle Fackle's liability to pay redress, albeit she considered it merely what she called a regulatory liability, not a legal liability for the purpose of the Act, we'll come to that. But she considered that that liability, such as it was for the, quotes, same damage, close quotes, as any liability that GECB might have had to customers in private law. Can I show you what she found there? It's in the judgment, page 182 of the core bundle, paragraph 362. On the bottom of the page, under the heading, same damage, she makes the point accurately that the 1978 Act only requires GECB liable for the same damage as Fickle Fackle, not the same damages. In other words, what matters is whether the same underlying loss is being compensated for. She said, as recognised in that case, a practical test, which can sometimes be useful to ask, is to ask whether the discharge by Fickle Fackle of their liability would pro tanto discharge GECB. Pausing there, if a customer, having received disp redress, then went off and sued GECB for an unfair relationship claim or in common law negligence and wished to recover the same compensation, the obvious answer was that would not be possible. That would be double recovery. She says, therefore, in this case, it undoubtedly would, and I accept that a regulatory liability to pay redress is not so fundamentally different from any liability that GECB might have incurred to customers as to take the case out of the statute altogether. Had the point been live, I would therefore not have found against AXA on this ground alone. Now, the point was not live at that stage because she'd found on various other grounds that we did not have a liability of the right sort to satisfy the Contribution Act. But if we had, it would be for the same damage. And I draw that to your attention because although there's no respondent's notice in relation to the cross appeal, there is a hint in Santander skeleton, which we'll come to, that they disagree with that analysis. That's the first proposition. The second proposition is this: if the redress had not been paid, customers could have sued in private law for the same compensation for the same damage that they had suffered. And here can we look at DISP 1.4, that's quoted in the judgment, paragraph 288, which is in this bundle at page 167. And the court sees there at the bottom of the page, first of all, DISP 1.4.1R. Just to be clear, the significance of the letter R is that that signifies that that is a rule. And a rule is, as we'll see, one which is actionable in private law under section 130, as opposed to, for example, G, which simply means guidance. So you see there what must happen once a complaint has been received by a respondent. It must, one, investigate the complaint competently, diligently and impartially. Two, assess fairly, consistently and promptly the subject matter, whether it should be upheld, what remedial action or redress or both may be appropriate, whether it has reasonable grounds to be satisfied. Another respondent may be solely or jointly responsible. Number three, to offer redress or remedial action when it decides this is appropriate. And then number four, importantly, comply promptly with any offer of remedial action or redress accepted by the complainant. So that is an obligation which arises at the end of the process, that number four. When there has been a determination that redress is appropriate, a determination by Fickle Fackle or by their own complaints handlers, then it becomes an obligation under that rule to pay whatever redress has been accepted. And then the next rule is DISP 1.4.4R, and that deals with the position where there's a reference to the Ombudsman Service, where a complaint against a respondent is referred to the FOS. The respondent must cooperate fully with the FOS and comply promptly with any settlements or awards made by it. And the judge found that that included not just final money awards, which are themselves enforceable as judgments, but also provisional determinations. And so again, when the FAWS made a determination, there became an obligation under that rule to comply with it promptly. And then I've mentioned 138D of FISMA. Can I show you that, please? In the authorities bundle, tab 5, page 53. And I'm looking at 138D, subsection 2, a contravention by an authorised person of a rule made by the FCA is actionable at the suit of a private person who suffers loss as a result of the contravention, subject to the defences and other incidents applying to actions for breach of statutory duty. And so, in my submission, if there had been a determination either by Fickle Factor themselves or by the FAWS, and there was not prompt compliance by way of paying it, then the customer would have had an unanswerable claim in private law in the civil courts under that section for the resulting loss. And I asked rhetorically, what would that? Yes, Mother.
A moment ago you said that R in DISP signified a rule, and indeed the cross-heading to that particular rule does use the word rule.
Yes.
And that is then picked up by, I thought you said, section 138D.
Yes.
Can we just identify the...
Yes, my lord. It's in the first line, a subsection 2.
Yeah.
A contravention by an authorised.
Where are we told that R indicates rule for these purposes? Where's that link made?
That is in the FCA handbook, my lord. I will get you the reference for that.
You would have thought it would be a legal provision.
Well, the FCA handbook is itself delegated legislation made under a rule-making power.
There's probably a definition of rule somewhere in the statute. I noticed that there are certain exclusions in subsection 5. Anyway, I don't want to waste time, but
No,
I was just to show I was listening to what you were saying.
I never doubted it, my lord, but confirmation is always welcome. I will get you those references overnight because I can see you want to join the dots, but I don't regard it as controversial.
I'm sure you're right.
Certainly looking at the reproduction of the DISP handbook that we have at tab 6,
Yes.
you can see quite clearly the tran lines to the left, the difference R and G.
That's right.
It's rather similar to how they rejig the bar with conduct.
That's right. Indeed so. Grateful. And so going back, if we may, to 138D on page 53, one asks then, what is the loss that would be recoverable, would be sued for, would be pleaded under that claim? Well, the loss would have been, in my submission, the amount of redress in question. And what did that redress represent? Well, that redress, as we have seen, represented compensation for the damage suffered by the customer as a result of having been missold PPI. So this, in other words, what the judge rightly, in my submission, found was the same damage as GECB would have been sued for if it could be sued in private law. The third proposition then, and this is where the real battleground is were Fickle Fackle thereby liable for the purposes of the Contribution Act? Now, there, can we go to the Contribution Act? It's in tab 2 of the Authorities bundle at page 13. And I know that this relatively short statute will be familiar to the court, but if we can remind ourselves of it, please. You will see section 1.1, subject to the following provisions of this section, any person liable in respect of any damage suffered by another person may recover contribution from any other person liable in respect of the same damage, whether jointly with him or otherwise. So breaking that down, we say the person here liable in respect of damage is fickle fackle. The damage suffered by another person, that other person is the customer, and the person from whom contribution then is being sought, who's liable in respect of the same damage, is GECB. Section 1(2) over the page provides that a person shall be entitled to recover contribution by virtue of subsection 1 above, notwithstanding that he has ceased to be liable in respect of the damage in question since the time when the damage occurred, provided that he was so liable immediately before he made or was ordered or agreed to make the payment in respect of which the contribution is sought. And I emphasise there the disjunctive formulation in the penultimate line, before he made or was ordered or agreed to make the payment in respect of which contribution is sought. In other words, the statute is making clear that there is no need for a judgment, there is no need for a settlement, there is no need for an agreement of any kind. Simply making the payment is sufficient, provided that the person is relevantly liable to make it. Subsection 3 makes provision as regards the person from whom contribution is sought, in this case GECB, and it says that they'll be liable, notwithstanding that they have ceased to be liable in respect to the damage in question since the time of the damage occurred, unless he ceased to be liable by virtue of the expiry of a limitation, a period of limitation or prescription which extinguished the right on which the claim against him in respect to the damage was based. So that might answer any question in the court's mind as to limitation of the claims, the hypothetical claims, which we'll come to under grounds 3 and 4 against GECB, because in negligence, for example, it doesn't matter that those claims, many of them would have been time barred, because the relevant time bar limitation is a procedural bar and not one which extinguishes the right itself. And so the fact that many claimants could not in fact have sued GECB for negligence, say, is no barrier. 1(4) is about bona fide settlements, which we'll come back to under ground 2. And then, crucially, we have two interpretive sections, 1(6) and then 6(1). And these are the where the key dispute lies. 1(6) references in this section to a person's liability in respect of any damage, or references to any such liability which has been or could be established in an action brought against him in England and Wales by or on behalf of the person who suffered the damage. And that's why my Lord Justice Lewison was absolutely right to say the test is, could they have sued for it? And that's what that is making clear. The related interpretive provision, which Parliament in its wisdom has chosen to place a few sections down, is 6(1) on page 16, where again reference is made to a definition of liability, where in 6(1) it says a person is liable in respect of any damage for the purpose of this act if the person who suffered it is entitled to recover compensation from him in respect of that damage. Brackets, whatever the legal basis of his liability, whether tort, breach of contract, breach of trust, or otherwise. And so having looked at those sections, I hope it becomes clear why I've been labouring earlier on these concepts of what was being compensated for by redress, the damage suffered by the consumers, and what would have happened if the redress wasn't thereby paid. They could have sued for it and gotten an award in court. And we say that satisfies those interpretive provisions. Looking first at 6(1), I would invite the court to ask itself, were consumers who had been missold PPI entitled to recover compensation from fickle fackle in respect of the relevant damage? We say yes. They were entitled.
I thought you were putting it rather more narrowly. We've got three different scenarios. One is a consumer complains that they have been missold insurance. The second is a consumer complains that they have been missold insurance. Fickle Fackle go through the DISP procedure and offer redress, which the consumer then accepts.
Yes.
And the third is that the consumer, for one reason or another, goes to FOSS, and FOSS makes either a provisional or a final award.
Yes.
Now, I understood you to be saying that it was in the latter two situations that an obligation to pay crystallized, and that if the regulated entity failed to pay either an amount which had been offered and accepted by the consumer or an amount determined by a FOSS, then the consumer could sue for that payment. Are you now saying that if either the regulated entity doesn't go through the complaints handling process, or as a result of the complaints handling process decides that redress is not appropriate, that the consumer then has some cause of action? And if so, what is it?
Well, your Lordship is right that those are the three scenarios. In order to succeed on the facts of this case, I only have to persuade you that the second and third are within the Act, because every single amount of redress claimed in these proceedings was within either the second or the third scenario. As a matter of principle, I would, to the extent helpful and interesting to the court, say that in the first scenario, there is at that stage a sufficient liability as well, because there is a legal obligation to comply with a process to properly assess and to then pay out whatever is the result of that assessment.
You have a hard time saying that was the same damage.
Well, my submission in that circumstance would be that it is the same damage that ultimately is being compensated for, because
if I have a claim,
yes,
and my lawyers allow it to be time barred, and I sue my lawyers, that's not the same damage as the claim, as the House of Lords said in Royal Brompton.
I accept that, my lord, and the reason I say this is different is because the reason that you are going through that process in the first place is not that the person doing the assessment process, it has been appointed either voluntarily or by statute as some sort of independent decision maker in the case of the regulated entity. It is because that regulated entity has itself been a party to the complained about and impugned sale. And therefore what is being complained about is ultimately the same damage in terms of the mis-selling. But as I say, I don't wish at 3 o'clock to be more ambitious than I need to be. And your Lordship is absolutely right that in my submission it is enormously significant and disposes of a great deal of legal debate that in this case it had gone further and there had become, either through self-assessment or through the FOS, a crystallised amount, which, as we've seen, there was a liability to pay and a private law right of action. That's 6.1. If we flick back please to 1.6 on page 14. Again, are we within that? Was the liability in respect of the damage one which had been or could be established in an action brought against Fickle Fackle in England and Wales? Well, it had not been established, but in my submission it could be established. In my submission it inevitably successfully would be established if it wasn't paid and the consumer chose to exercise their private law right of enforcement under section 138D2. Now, in a sense, I could move on there, but I should show you why the judge took a different view. But before I do, I pause to emphasise that rather like the debate that was happening between my learned friends earlier, my analysis so far has rested exclusively on the language of the statute read alongside the language of the other provisions. I've not had resort to Pepper and Hart and to the speech of Lord Scarman, which is in our supplemental skeleton. I will touch on that very briefly later, because I say it would be absurd were any other analysis to follow. But I emphasise at this stage that this is, in my submission, a straightforward orthodox reading of the statute. Can I show you why the judge disagreed? Core bundle, tab 9, page 177, please. And if the court sees, please, paragraph 336, halfway down the page. The judge said, as far as the redress payments are concerned, I've already concluded AXA was under a regulatory liability to pay redress by virtue of its obligations under DISP. However, Santander argues that this is not a liability that could have been enforced as such in the civil courts by the complainants. The only claim that could be brought would be for default in the handling of the complaint, whereas none of the claims by consumers was made on this basis. And that remains, I think it's fair to say, the essence of Santander's position on this appeal, as you'll have seen from their skeleton. The judge says in the next paragraph, while I rejected this argument in the context of the indemnity claim, I've concluded that in this context, correct, section 1.6 contemplates that the action brought by the person who suffered the damage must be one which has established or is capable of establishing the liability. However, she says, the only civil claims that could have been asserted by customers would have been for breach of rules 1.41 or 1.44 of DISP, and far from being in breach these rules, AXA Genworth appear to observe them meticulously. Well, pausing there, it's right to say AXA and Genworth observe them meticulously, and that's why in the end no consumers had to go so far as to exercise their enforcement rights under section 138. But we say that, with great respect, misses the point that what is required is a very simple thing under the Contribution Act. What is required is to be under a liability and to make a payment in respect of that liability. And the distraction that was introduced by Santander and that the judge succumbed to was to worry unduly and irrelevantly about the precise form in which that liability or a complaint was asserted, and to worry unduly about the precise way in which a complaint was resolved. It doesn't matter, in my submission, what liability is asserted when seeking payment. It doesn't matter what liability a payer has in mind when making payment. What matters is whether objectively a payment has been made which has satisfied a legal liability. And so a great deal of Santander's skeleton argument is concerned with pointing out that when a complainant made a complaint, which was then the subject of a determination, they did not invoke private law grounds. They simply said, in most cases, using a standard form questionnaire, I have been missold PPI in various ways, and these are my account details, and I'd like compensation. So there was nothing like a particulars of claim and a defence, and so. Nor, and this was a point which occupied a great deal of emotional heat at trial on Santander's part, nor was there an adversarial process. There was no defence. There was no demand for disclosure in anything like a CPR sense from a complainant. There was no cross-examination of complainants. There was instead a following of an essentially commoditised decision-making process in the context of complaints which were typically in themselves of fairly piddling value. Nevertheless, in my submission, the result of that process was a recognisable legal liability in the sense of an obligation to pay a sum of money, which, if not paid, could be sued for unanswerably in court. And it does not matter whether the process leading to the creation and recognition of that liability was itself recognisable as some sort of analogue of a private law claim. That is not the test, and it's not the requirement under the Act.
So the argument really, I think, is this, isn't it? That Genworth AXA, or whoever it was under a regulatory liability, or under an obligation owed to the regulator to deal with complaints under DISP. But once it had dealt with the complaint and offered redress to the consumer, which the consumer accepted, then had a parallel private law obligation to the consumer to pay that redress, for which the consumer could have sued in court if need be.
That's right.
And likewise, although the Ombudsman doesn't necessarily follow strict legal rules in deciding what compensation should be awarded, once the Ombudsman has decided, then again the consumer, if the consumer accepts the award, which I think the consumer doesn't have to do,
No.
Then the consumer can sue for that.
That's right. Yes. And I say that is a liability which satisfies the requirements of the Contribution Act. And indeed, I say that's not a surprising result. And just to emphasise the point I made about there not having to be any particular process of complaint, consideration and determination in order to get within the Act, as long as what ultimately there is capable of being shown as a liability. One can consider the facts of the BDW case, which is in the Supreme Court very recently. And it's in the bundle, we don't necessarily have to go to it at this point, but in simple terms, there, a developer, which I think ultimately obtained the services of my learned friend Mr. Howard in the Supreme Court, had made remedial works to a building and then sought contribution from the contractor. Now, in that case, as it happened...
Structural engineers, I think.
Sorry?
The structural engineers, I think.
I'm sorry, yes. From the structural engineers. And the important point for this stage analysis in that point is that the remedial work was done not only in the absence of a judgment or a settlement agreement requiring it to be done, but effectively unilaterally. They'd got permission to interfere with people's flats, but they had done it, the developer, in anticipation of avoiding claims. And so a person seeking contribution, in my submission, can't be any worse off as a result of having made a decision to pay through a particular regulatory process, as opposed to simply doing it unilaterally. The question is, when they pay, can they properly be said to be liable? And we say there, liability is a very straightforward, ordinary term. In my submission, being liable to do something is to have an obligation which, if not fulfilled, is capable of being sued upon. Now, there is a distinction which I should front up to about whether, at the time that payments were made, there was a fully concluded and completed cause of action under section 138D. And it may well be said there was not a concluded cause of action under 138D because, as the judge noted, the obligation to pay promptly was complied with promptly. And so consumers didn't come to the stage where they could have turned up in court and presented a claim for. But in my submission, that would be a surprising distinction to draw when the words cause of action appear nowhere in the Contribution Act. Instead, the Act talks, as we have seen, consistently of liability. I accept, of course, it must be a legal liability, and it must ultimately be one capable of legal enforcement. But to take a simple example, at the risk of glibness, supposing that a person signs a binding contract to deliver to his counterparty in 6 months' time a particular consignment of goods. They have then 6 months to deliver. And it's not until 6 months plus a day or plus an hour that the counterparty has a completed cause of action for breach of contract. However, can the person who signs the contract promising to deliver immediately be said to be liable to deliver the goods? And we say, yes, he has a legal obligation, which if he doesn't comply with, renders him susceptible to legal enforcement. And we say to get distracted by the precise timing of when a cause of action accrues is to miss not only the broad and non-technical language of this statute, but also the obvious purpose of this statute. And one of the obvious purposes of this statute, which I don't apprehend there can be any dispute about, is to avoid a putative contribution claimant forcing the underlying victim of a wrong, the underlying sufferer of damage, in this case the consumer, to avoid them forcing that person to fight to the bitter end in order to preserve the putative contribution claimant's claim for contribution against the putative contribution defendant. And that's precisely, I mean, not only is that an obvious statutory purpose, it's obvious from Section 1.4, which gives special provision and protection to bona fide settlements, and it's obvious from that disjunctive language that we looked at in Section 1 about made or agreed or being ordered. One doesn't have to fight until the end, until there's no option but to pay under an order of the court. The question is whether there is ultimately a liability of the type capable of legal enforcement. And then just finishing off on the judge's paragraph 337, if we may, back in core bundle, page 177. Halfway down 337, she said it may be, likewise, it may be that AXA Genworth were under regulatory liability to pay redress or satisfy FOS awards. That was because of an obligation owed to the regulator, not because they were under any liability to the consumer. You have my submission on that. They were, in fact, at least at that stage where the payment had crystallised. Moreover, she said, the obligation under Rule 1.4.1 is to pay redress when the insurer decides appropriate to do so. It's difficult to see how an action for breach of 1.4.1 can prescribe positively how that discretion should have been exercised. Well, we've had that discussion.
That was what I call scenario 1.
Yes, exactly right. And
you say you don't need to rely on that.
Don't need to rely on that. And I say, if for some unforeseen reason you consider that I do need to rely on that, I'd say, well, someone who turns up with a complaint that they have been caused damage by the mis-selling to them of Fickle Fackle's PPI, they have a right under DISP to have that properly assessed and have proper payment made based on that assessment. And that is ultimately, again, legally enforceable under Section 138D2. And then the final point says it's difficult to see how an action for breach of 1.41 can prescribe positively how that discretion should be exercised. Well, again, we say that's academic on these facts, but in fact, as a matter of principle, the right to have a reasonable sum paid in compensation for damage is a legal right. It involves a process of assessment. It's not a crystallised debt, but nevertheless, it is a liability. as to Santander's position on ground one, they largely adopt and build on the judge's analysis. You have my submissions on that. Can I just show you a small number of paragraphs in their skeleton, which is core bundle tab 5. First of all, page 71. This is their skeleton argument on the cross appeal. This is the point I raised earlier when I showed you what the judge found in paragraph 362 of the judgment about the same damage. This seems to come perilously close in my submission to seeking to challenge that, where it said that an action under 138D2 would not be an action to establish liability in respect of a complaint in the sense required under section 1.6 of the 1978 Act, insofar as an action under 138D2 would involve any liability for damage for the purposes of the 1978 Act. It would not correspond to any such liability in respect of an underlying complaint because there's no such liability at all. I confess I find that slightly hard to follow, but in my submission, the simple situation, or the simple question that I invite the court to ask themselves is, what is the damage that is being compensated for when there is enforcement action being taken under 138D2? Not what the liability is. The Act doesn't care what liabilities are. It focuses on whether there is any liability for the same damage. It's the same damage that is the connecting concept between contribution claimant and defendant.
Well, are you right in saying that the Act doesn't care what liability is? It surely cares to the extent that it must be a liability capable of being established by a civil action in
You're
court.
right, I spoke loosely. But within that confine, what section 6.1 does, as we've seen by the parenthesis of whatever the nature of that liability, it is blind as to what kind of legal liability it is. In other words, to the extent this paragraph seeks to say there has to be a consistent type of liability, subtype of liability, identified at each stage of a process, or between contribution claimant and defendant, that's the wrong question. The question is it the same damage for which the contribution claimant can identify a liability? And we say we can and we do. Over the page, please, or rather the bottom of that page, just to clarify, paragraph 27, there's a reference there to Schedule 17, paragraph 16 of FISMA. We don't need to trouble you with that. Those are final false awards. None in fact arose on the facts of this case, as was made clear below. So your lordships can ignore that for present purposes. And then finally, in paragraph 34, a couple of pages on, page 75 of this bundle, it said that it bears emphasis that such regulatory responsibility, i.e. DISP, was imposed in the present case as part of a statutory regime and in the exercise of powers that Parliament conferred on the regulator. The regulatory regime confers on regulated persons such as AXA no right to seek contribution from others towards the costs of doing that which the regulator requires to be done. Respectfully, it's a matter for Parliament and the regulator to judge whether it's appropriate having regard to the various policy considerations that would bear on this question. It's not for the court to do so by extending the 1978 Act. Well, plainly, if the court finds that I'm wrong in my construction of the 1978 Act, then that's the end of it. One doesn't get into questions of deference to Parliament or the regulator. But if I'm right on that, if you're with me on that, and this is prima facie a liability which can be recovered, then the fact that the liability on the part of the contribution claimant arises out of regulation is, in my submission, nothing to the point. It's simply a liability. Some liabilities arise from regulation, some from contract, some under the common law of negligence, etc., etc. Unless there is something in the statutory scheme which is said to be inconsistent with the idea of contribution being sought, then why on earth does this point, quotes, bear emphasis It doesn't, in my submission. It's a distraction. There is every reason that a regulatory liability, which happens to have fallen on Fickle and Fackle because of the decision of Parliament, can nevertheless be subject to contribution from their agent, GECB, which was doing the actual mis-selling, and as it happens, was massively profiting disproportionately compared to its principal by doing that mis-selling. There's no undercutting of the statutory regime. The consumers are compensated under DISP in a quick and cheap and straightforward process. And to the extent a principal has a complaint against its agent, the Contribution Act, as part of the general law, steps in. So, my Lords, my Lady, I will say no more for the time.
What
Sorry.
you say is that the scheme under DISP may well be a regulatory scheme,
Yes.
but Parliament has decided that private persons who suffer loss as a result of a breach of that regulatory scheme are entitled to bring proceedings.
Yes, that's right. And Parliament has decided more broadly by the 1978 Contribution Act that where someone is under a liability, a legal liability, regardless of what type of legal liability that is, including breach of statutory duty, they can recover against others who are liable to the same underlying victim. Parliament, when it passed the
Can you say the last bit again?
Parliament by the 1978 Act, the Contribution Act, has decided that a person who is liable to the victim of damage can recover contribution against a third party who is also liable to the person who suffered the damage. And the fact that the contribution claimant's liability is a regulatory one is nothing to the point. On the contrary, when one looks at 6.1 of the Contribution Act in the authorities bundle, page 16, you can see in the parenthesis at the end, Parliament has taken pains to be expansive, whatever the legal basis of his liability, whether tort, breach of contract, breach of trust, or otherwise. Breach of statutory duty is an established category as well. And Parliament, when it passed the 1978 Act, was just as much Parliament as when it gave the FCA delegated rulemaking power under FSMA. There's no inconsistency. So with that, I wasn't going to say any more on statutory purpose. We do say, as we've said in our supplemental skeleton in particular, that if you find there is ambiguity, or for some reason that the absurd consequence would be that Fickle Fackle would be better off in terms of contribution if they had failed to comply with their regular obligations and been sued under 138D to, on any view, produce a standard civil law liability, that would be absurd. And you can look at what Lord Scarlett said when he introduced the bill in the House of Lords, and you can look at what the Law Commission said when they prepared the report that led to the legislation. And all that makes clear that one is to avoid technicalities. And we say whatever arguments Santander will make in due course will be of the highest order of technicality. May I then move on to ground two? Cross-bill ground two concerns, as you know, the official receiver settlement. Can I show you that, please, in the supplemental bundle, tab 2, and it starts at page 107. You see there, it's headed at the top, confidential without prejudice, subject to contract, but it was in fact executed, and so that language has fallen away. Dated the 3rd of December 2021, between the claimants herein, the respondents, and the official receivers who are listed. Tab 2 of the supplemental. And if we go to page 108, please, you will see the recitals, whereas letter A, the official receiver sought to pursue complaints and or claims against AXA France, that's the claimants in these proceedings, relating to one or more PPI policies of various types in respect of multiple forms of credit purchased by the individuals listed in spreadsheets submitted to AXA France. B, as an alternative to an assessment of each individual complaint in accordance with DISP, the parties have agreed a full and final settlement of AXA France's entire liability to the official receiver in respect of the OR listed claimants, in respect of the relevant PPI policies, without any admission of liability by AXA France or any of its related parties. This agreement records the terms of settlement. So just to try and fill in a little bit of colour there, this was, as you can see, a bulk settlement. We've not troubled you with the Schedule 2 referred to, but there were some 95,000 PPI policies that were the subject of this settlement agreement. And you will see the reference in letter B as an alternative to an assessment of each individual complaint in accordance with DISP. That's a very important consideration, not least because the rules are that when a consumer wishes to refer the determination of a complaint to the Financial Ombudsman Service, a flat fee was payable for that reference, not by the consumer, but by the regulated entity, and that was in the region of £550 per complaint. And so one could have a complaint where, if upheld, would lead to compensation of £5. But if there's a dispute, it could lead to a massively disproportionate cost. And so one can see, even leaving aside that, simply processing 95,000 complaints is an expensive, burdensome process, why there was a rationale for a bulk settlement. We can see how that worked in clause 1.2 in definitions. You see there the definition of claim or claims, broadly defined without limitation as any and all actions, claims, rights, demands, and set-offs, etc., whether before any court, tribunal, regulatory or other authority. And it then refers over the page specifically but without limitation to this. And then we have further down that at the end of that section of definition, settlement amount means the sum of £24 million. If we can go please over the page to clause 3.4 on page 110. In consideration of the payment of the settlement amount, the official receiver undertakes not to submit or support the submission by any OR listed claimant of any complaints relating to any of the relevant PPI policies, nor initiate, support or bring any claims against AXA France or its related entities. And then B, fully and finally hereby releases and forever discharges AXA France and its related entities from all claims relating to any of the relevant PPI policies. And then finally, just to finish off looking at the agreement, over the page please, paragraph clause 4.4 on page 111, AXA France warrants and represents the settlement amount equals the estimated total redress and related administration costs that would be payable based on AXA France's historic complaints management experience if the official receiver submitted a mis-selling complaint in respect of all the relevant PPI policies disclosed by the official receiver to AXA France, and AXA France assessed each such complaint individually in accordance with DISP. And so you can see there that as part of the process of avoiding the costs of processing, what is being warranted and represented here is that AXA France, the claimants herein, have gone through a process of considering, based on their long unhappy experience of having to deal with many other complaints, what the likely result would be if those processes were followed for these complaints. And 24 million was ultimately the sum settled for. Cross Appeal 2, having shown you the factual context, is a very short point indeed. And it's summarised in our skeleton argument, our main skeleton, core bundle, tab 4, page 56. and it's all on that page, but essentially what we say is the judge fell into error by saying that the official receiver settlement was not a bona fide settlement or compromise of any claim made against the claimants for the purpose of Section 1(4) of the Contribution Act, because she noted the official receiver had not actually made complaints, and therefore there were no or not many live complaints actually going through the DIS process. We say, and we quote Clark and Lindsell in the next paragraph, we say one doesn't need, for the purposes of Section 1(4), to have had a claim or any particular form of complaint issued. Instead, what one requires is the intimation of a claim or complaint, which can be the subject of a sensible, recognisable settlement. And we say that makes perfect sense, because otherwise a putative contribution claimant could not settle a claim advanced by a letter before action, absent proceedings actually being issued. And we say that would be contrary to the purpose of Section 1(4). Can I just remind you of Section 1(4), which we rather skipped over earlier on? It's in the authorities bundle, tab 2, page 14. And you see there, the controlling concept is whether a person has made or agreed to make a payment in bona fide settlement or compromise of any claim made against them in respect of any damage. And they shall be entitled to recover contribution in accordance with this section without regard to whether or not he himself is or ever was liable in respect of the damage, provided, however, that he would have been liable, assuming that the factual basis of the claim against him could be established. And so it's a deeming provision.
How do we know what the factual basis of the claim was? We've got a recital in the settlement agreement,
Yes.
which says that the OR sought to pursue complaints and all claims against AXA, but that's all we know. We don't know what the claims were.
It's a very fair point, my lord. The answer is the complaints were intimated as complaints about PPI mis-selling on effectively a commoditised basis. And it's absolutely right to say that there was no breakdown for each of the 95,000 complaints as to precisely what grounds of complaint.
But in order to claim contribution under Section 1(4), leave aside the question of whether a claim was made, and that was the judge's reason.
Yes.
But you would have to establish, would you not, that AXA would have been liable, assuming that the factual basis of the claim against AXA would be established. But we need to know, don't we, what is the factual basis of the claim before we can reach any sort of view about whether it could be established.
Yes, absolutely, my lord. And your lordship is right to distinguish between the point you're putting to me now and the judge's point. I'll move on from the judge's point. I'll consider that asked and answered. As regards your lordship's point, the answer is there may be a special approach required as a matter of evidence where there is a bulk settlement of a very large number of claims of a recognised sort, but in the absence of particularisation. And the special approach that we would advocate for on remittal would be that it is appropriate to assume that the types and ratios or percentages of mis-selling seen in that 95,000 population of settled complaints would be substantially similar to the overall types and proportions of mis-selling seen in the broader population of complaints made. And that would be a matter for the court to decide upon whether that's right or wrong. But we say, as far as the judge ruled out in limine that evidential argument, that was wrong on the basis she gave. And we also say that even if ultimately the judge on remittal finds that one simply cannot get meaningful protection from section 1.4 in that type of bulk settlement, that doesn't mean we're outside the Act. It simply means we're outside the specific pro-contribution claimant deeming provision of section 1.4. In other words, what will have happened is there will still have been a payment made, 24 million, in respect of all those policies. Inevitably, some of those policyholders will have had good complaints and some will not have had good complaints. And therefore, it will be a matter for the court to determine what proportion, if any, AXA can show would have had good complaints, and therefore what proportion of that 24 million was a payment made in respect of a liability. And I accept that in that situation, unlike under the redress payments that I've addressed you on under ground one, we would be in your lordship's first scenario, not the second or third, because there wouldn't have been a case-by-case assessment. But we say that is a matter eminently suited for the sort of sampling approach that you have not been unduly, I hope, troubled with, but which Mrs. Justice Dye certainly was, in that there was a disclosure of sample files below. There was then a very elaborate Scott schedule process to produce points of principle and so on. There were statisticians instructed as to the representativeness of that sample and so on. These are all arguments which the commercial court in particular is well used to dealing with in all sorts of claims, but particularly insurance claims. I should be careful what I say the commercial court is well used to dealing with, because you have much more recent experience than I do. But it's not unusual in my submission for large-scale, low-value insurance claims and others to be dealt with on a sample basis, and for extrapolation then to be the subject of debate between statistical experts. Yeah. And that's what we would say is appropriate in this case. Can I just show you and deal with 3 points made by Santander in their skeleton on this ground? First of all, please, core bundle, tab 5, page 76. And I'm looking at their paragraph 38. It says AXA does not challenge these findings, i.e. the finding that no claims had actually been made. They are fatal to ground 2. Well, you have my submissions on that. Then they go on, whereas ground 2 asserts that the OR settlement was a bona fide settlement, etc., the judge made no such finding. That too is fatal to ground 2. Well, if that means that the judge didn't find that there was a settlement of complaints that would otherwise be issued, in my submission, that's what a settlement agreement is, and I've shown you the terms of that settlement agreement. To the extent that means the judge didn't find it was a bona fide settlement, well, in my submission, that's right, but it wasn't an issue as to whether it was a bona fide settlement. There was no allegation that the settlement was other than bona fide. There was a pleaded allegation, just for your note, it's paragraph 53.4 of the defence, which is core bundle, page 297, that we were put to proof as to whether it was a reasonable settlement. But, of course, there's a great difference between putting to proof as to reasonableness of settlement and asserting that a settlement is not bona fide. For section 1.4, the relevant question is whether it's bona fide. Anything beyond that is a question of apportionment and analysis on that front. The second point in the skeleton is the next paragraph, paragraph 39, where it is noted that the vast majority, asserted that the vast majority of the bankrupt estates cannot be taken to have been able to identify, to make or have had a good complaint at all. AXA is therefore seeking contribution for complaints that were never made and for complaints that never could have been made. Well, again, you have my submissions. At their height, my submission is that what we should be allowed to take advantage of the deeming provision of 1.4, and that therefore the settlement as a whole should then be assessed on the basis by reference to the experience of complaints across the broader population. But even if we don't get that, still that's an argument that can be had on the evidence that some of them would have been good complaints, some bad, but because some were good, it's a question of extrapolation. And then finally, in paragraph 40, we have the point about articulation, and Your Lordship, I've touched on that already, so you have my point, that even if it's not within section 1.4 as being sufficiently intimated, nevertheless, it is within the Act as a whole.
Does the judge deal with any correspondence that intimates these claims?
No.
Do we have any correspondence which intimates these claims?
You have nothing in the bundle beyond the settlement agreement itself.
And all that tells us about the claims is in recital A.
Yes. Yes.
One of the footnotes in the skeleton you've just taken us to takes us to the judgment at 302 to 304, which the judge herself cross-referred to in dealing with this aspect. And that seems to give a little more information.
Yes. Well, can I?
There'd be no actual complaint.
There'd be no actual complaints, my lord. That's absolutely right.
So it's not as if this was a situation where you had a standard form which was filled in by potential claimants, which then was the subject of which were then forwarded as a mis-selling claim. It didn't reach that stage.
It didn't. No, I need, my lord. That's absolutely right. And there was a very good reason for it not to reach that stage, in the sense that when it reached that stage, if there had been submission, then there would have been, absent a settlement, a requirement promptly to deal with them and to start that process going. Instead, what the settlement agreement sought to achieve, in my submission quite understandably and responsibly, was to stop that being required, to nip it in the bud, and to say, we will pay the money and you will not start that process of requiring assessment.
Right.
That's what I wanted to say on ground 2. We moved then under ground 3 to the other side of the coin, in terms of now we're looking at GECB's notional liability. And I accept readily that here we are in the realms of hypothesis, because we're not dealing with actual claims having been made by these consumers against GECB. The reason for that is, of course, they perfectly reasonably took the course of using the pro-consumer convenient and cheap process of DISP. Nevertheless, under ground 3, we say if they had wished to sue GECB in negligence, they could have done so. There was a relevant duty of care. But before I go into the law on duty of care, can I just, at the risk of labouring a straightforward point, just remind the court of how many contracts were involved in the sale process of PPI when someone actually walked into a department store. There were 3. The first contract was when someone walked into a shop to buy whatever they might have expected to buy going into that shop, a pair of trousers. And they went to the till, handed them over, and concluded at that stage a contract of sale with the shop assistant in their capacity as employee of the retailer. And that's all very straightforward. The second contract was then when the shop assistant invisibly put on a different hat, that hat being that of an agent of GECB in respect of the sale of its credit product, the store card. And they would, in simple terms, say to the customer, that's a fantastic pair of trousers, but you don't want to pay for it today, do you? Or if you take out a card, you can get 10% off, something of that nature. And they would then, if the customer was willing, conclude in that capacity the second contract of credit with GECB. At that stage then, there was potential for the third contract, which was concluded between the same human individuals but different legal entities. The consumer was then offered PPI to secure the balance on their exciting new store card. And at that stage, the shop assistant took off their second invisible hat to replace it with a third, that being a sub-agent of GECB, with GECB at that stage in respect of the PPI being the agent of Fickle Fackle as the insurance underwriter. And the reason I emphasise that is to emphasise that when the PPI policy, when the contract was entered into, it was very much not just a secondary product, but a tertiary product. Trouser contract plus credit contract plus potentially PPI contract. And not only that, but in practice, it was very much an ancillary or tertiary product. And just to remind you of what the judge, one of the findings, just one of them, the judge made in this regard. If we look please in the core bundle, tab 9, page 112, you should see paragraph 60 of the judgment at the bottom of the page. It was not disputed that GECB's primary concern was with its core lending business. That the focus of the transaction was therefore very much on the store card. On GECB's own estimate, typically only around 20 to 30 seconds was devoted by sales staff to selling PPI in what was generally a fast-paced and pressured environment, particularly during end of season sales. It was not disputed that sales staff were often part-time or temporary, for example, students or teenagers doing weekend or vacation works, and they were frequently incentivized to sell as many policies as possible. Some stores, as noted, nonetheless offered customers the possibility of going to a separate part of the store to consider or discuss the credit agreement and ancillary PPI before signing up. That was, on the evidence, very much the exception rather than the rule to have a separate desk. But in any event, even if that was the case, still, as you see there, the primary focus was on the credit agreement rather than the ancillary PPI. And beyond that, one more factual point to remind you of is that as well as the selling process not really being focused on the PPI, there was a broader interrelationship between the second contract, the credit agreement, and the PPI. That interrelationship was partly, as I've just explained, because one only got to the PPI stage at a stage where the credit agreement had been entered into, because only then was there something to protect. So by that stage, the customer was GECB's customer. Now, you may have seen in the agency agreement there are repeated references to GECB's customers. But further, as my learned friend Mr. Green mentioned earlier on, the PPI product actually had the function of protecting GECB's own credit risk. In other words, when the policy paid out, it paid out to GECB. And for your note, this was actually then in the agency agreement 6.1L, where it provides that the way in which the insurers would satisfy a policy claim would be by crediting the sum to the store card account. And so GECB had that incentive and had that benefit. And none of that was unusual in the PPI industry. GECB was, I think, unusually active and dominant in the industry, but that model is a familiar one. And if you want to see a reference in authority to a recognition of what I've just said about the intimate interrelationship between a PPI policy and its host or mother credit policy, credit agreement. There's one in the authorities, just for your note. It's the Smith and Royal Bank of Scotland case, volume 2 of the authorities, tab 25, page 655, and on page 680, paragraph 79, Lord Legate there explains that point. So, with that factual context in mind, can I then address you on the test for duty of care in these circumstances? And both sides happily are content with the statement of the law in the case of Custom and Excise Commissioners and Barclays. So can I show you a couple of passages from that, please? It's in the authorities bundle, tab 13. Starts on page 210. In brief summary, the facts of the case were that a bank had been notified of a freezing injunction that the customs commissioners had obtained in respect of outstanding VAT. The bank nevertheless allowed payments to be made out of the account innocently, but the commissioners said negligently, and the commissioners sought damages from the bank for failing to prevent payments contrary to the freezing injunction. The House of Lords found that there was no duty owed by the bank to the commissioners because there was no assumption of responsibility, and also the House found that to allow breaches of an injunction in those circumstances to sound in private law would undermine or be inconsistent with the primary enforcement of an injunction being a matter for contempt proceedings. But as to the general principles, can we look, please, first of all, page 228 of the bundle. You should see Lord Hoffman in actually, I apologise, 227. You should see Lord Hoffman at paragraphs 35 and 36. And I wonder whether I could just trouble you to read those two paragraphs. I'm grateful. And I won't seek to paraphrase Lord Hoffman, but I draw that to your attention because Santander lightly chide us in our skeleton for using the phrase assumption of responsibility in what they perceived might have been perceived by Lord Hoffman as a sloganeering way. It's not our intention. We entirely accept that one looks at all the circumstances, and in particular, as you will see from the references in there, to the Williams and Natural Life Health Foods case and to Henderson and Merritt, that there will be cases where there is not a straightforward bilateral relationship between the person said to owe the duty and the person to whom they're said to owe it. One can have tripartite or multipartite arrangements, and I'll show you one or two examples of that. But we accept and we aver that none of that is a barrier to the existence of a duty what one has to look at is the precise nature of the relationship, and in particular, how far objectively there was reliance placed reasonably on one party by another.
So in this case, we've got 3, possibly 4
Yes,
entities in the chain.
yes,
At the bottom of the chain is the consumer who buys the PPI policy. Next up is the shop assistant, who is an employee of the store.
retailer, indeed.
But you say in selling the PPI, the shop assistant becomes a de facto agent of GECB.
Yes, in selling the credit agreement.
But sorry, in selling the credit
They
agreement.
become,
And in selling the PPI, the shop assistant becomes a de facto sub-agent
sub-agents. Yes,
of GECB, which is in turn the agent
yes,
of FECL.
that's right.
So who's providing information on behalf of whom?
Well, that is the question. We say ultimately, first of all, it's not by any means impossible or unorthodox that any of those particular people could be sued in any of those particular capacities in circumstances where they are wearing multiple hats, and this is all part of one quick, fast pressured transaction. But what we say is, at least one, and the one on which we rely on, is that GECB, when selling to its credit customers as agent of FICL ancillary PPI, was reasonably to be expected by those customers to give them basic information about, in particular, their eligibility for the PPI. Now, the answer that the judge considered to be a knockout blow to that assertion on my part, which Santander invites you to find is a knockout blow, is that they say, and I quote their skeleton, there is a fundamental principle of agency law that GECB could not be liable in that situation because the information in question was being provided in respect of a product for which they were merely FICL's agent. And they say that that is a fundamental principle of agency law, which emerges from, in particular, the Williams and Natural Life Health Foods case, which the court sees cited among others by Lord Hoffman. And in my submission, that is an absolutely clear error of law. I don't say that if I can persuade you that it gets me home, plainly I'll have to show you that it's still, in all the circumstances, reasonable to identify a duty of care. But to strike it out on that basis, to say that never, as a fundamental principle of agency law, can an agent in that situation be liable, is legally wrong. Can I try and show you that by reference to a relatively recent authority which deals with, among others, the Williams case, and this point about agents and sub-agents. It's in the authorities bundle, please. Volume 1, tab 18, page 354. And I hope you see there the case of Invulnert Management and April Grange Limited.
Sorry, paragraph.
Well, I haven't got to a paragraph yet. It's in the authorities, page 354.
Thank you.
I'm grateful. And it is a first instance decision, although you see it was Mr. Justice Leggett as he then was. And in my submission, it's a helpful distillation of the authorities. before we go to the relevant part, in short, this was a case where there was a policy of yacht insurance that was voided because there had not been proper disclosure as to valuation. And the disappointed insured joined the brokers who had been involved in that process of arranging it, both the main broker, who was known as the producing broker, and also the sub-broker. So the main broker with whom there was a contractual relationship, and also their sub-broker had been involved. The sub-broker denied a duty of care, where it said it had acted only as the agent of the broker, so as the sub-agent, and had no direct dealings with the insured. Now, in the end, on the facts, the judge found that worked. There was no duty, in particular because there had been no contact between the insured and the sub-broker, and no evidence of reliance. So I flag that now, but can I look at what his lordship said were the principles? Can we turn, please, to page 425 in the judgment bundle, page 425. And paragraph 285 at the bottom is headed Henderson and Merritt. And this is worth looking at, because not least because Henderson and Merritt, as one of the locus classici of this area of law, the Lloyd's names and whether they were owed duties, was actually a case where the court found there was a duty owed by a sub-agent with whom there was no, in respect of what they called the indirect names, there was no contractual duty. So it's not at all dissimilar, my submission, to what we're considering. Can I invite the court, please, to read to themselves, please, 285 and 286. So what do I draw from that? First of all, as regards the helpful summary of Henderson and Merritt itself, that, as I say, involved a finding of a duty owed by a sub-agent in a tripartite relationship with no direct contract between the suing indirect names of the sub-agent. So much, I say, for a supposedly fundamental rule of agency law, which says that you cannot have as an agent liability to an underlying party. But also beyond that, I note in the second half of paragraph 286, of course it's right to say there will be some situations where a direct duty, a finding of direct tortious duty, might circumvent or short circuit, as his lordship says, a deliberate contractual arrangement. And that will be the case perhaps most often in certain building contracts. I accept that. That's highly relevant. However, I would invite the court to consider whether this situation that I've been describing and that the judge makes findings on is really analogous to an elaborate set of contracts for a major building development where the employer chooses to contract with one primary contractor and allow them to contract with subcontractors with whom they have no contracting relationship. Or whether this was, like his lordship noted in paragraph 287, a situation where the underlying damaged individual, whether the name in Henderson or the customer in our case, had no real choice. no choice in Henderson, because that was simply how the rules of the Lloyd's market worked. There were restrictions on the type of contractual structures that were permissible. And here, in our case, not because there were restrictions, but because the customer, when they were bounced into first a credit agreement and secondly a PPI policy, having gone in to buy a pair of trousers, could give no possible thought, even if they were so inclined, as to with whom they were contracting and what particular division of carefully calibrated contractual responsibilities they might be content with. There are exceptions. If members of this court had been offered a store card and policy, then such questions would have risen to your minds immediately, but not for the overwhelming majority of people out doing their Saturday shopping. And just to finish off on this case, you will see in paragraph, over the page, paragraph 289, I simply raise it as another example. The case in which the position of a sub-broker has been most extensively considered as BP and Aon Limited. That was a judgment by Mr. Justice Males, as he then was, and you see it described there. And that was simply another example of where, even in that circumstance where there were sophisticated major parties contracting, there was nevertheless found to be a direct tortious duty owed by somebody who was an agent of the primary contracting party in all the circumstances. And the circumstances there included, by contrast with this yacht insurance case, that in that case, Mr. Justice Males found there had been extensive direct contact between the sub-broker and the suing claimant, such as to give rise to a direct tortious duty, notwithstanding the contractual situation. So all of that is simply to try and clear the way from distractions based on assertions about agency law. And I will then turn, perhaps tomorrow if convenient, to the court, although I'm happy to continue, to my submissions based on why there should be a duty of care on these particular facts.
Right. Just taking stock of where we are, it looks as though we will finish this tomorrow, doesn't it?
I very much hope so, my lord.
Right. All right. Well, in that case, we'll adjourn now till 10:30. I hope we can finish this tomorrow. If we can't finish it tomorrow, I have to tell you that we will not be sitting on Thursday morning, but we could make ourselves available on Thursday afternoon. There's been an unexpected change in various arrangements.
I'm very grateful.
But
I think we should.
I would hope that we will not need any part of Thursday. 10:30 tomorrow.
All rise, able.